And a very good afternoon to all participants. Okay, first of all, I would like to welcome to Professor Dr. Zuhairah Ariff for today's session. So, inshallah, today we are going to have academic series talk entitled Hybrid Body Corporate Entity Special Reference to Malaysia LLP that will be delivered by Professor Dr. Zuhairah Ariff. And inshallah, this session we only have 45 minutes for the talk and then 15 minutes for Q&A session. Am I correct, Prof?
Yeah, I think that is good enough for afternoon session. I believe that
Okay.
I think this is the week for students and also the lecturers are finalizing their courses. So I believe that 1 hour is good enough for the academic talk, inshallah.
Okay. So I think now we have 70 participants. So without further ado, I pass to you, Prof.
Thank you very much, Dr. Tini. Assalamualaikum warahmatullahi wabarakatuh and good afternoon to all. First of all, I would like to thank everybody for taking your time to listen to the academic talk. I try to make it as brief as possible because the main objective of this academic series is to share some of the research conducted and also our output, new output findings out of the research that we conducted. So without further ado, I will start my slides. All right, I hope everybody can see my slide. Is it okay, Dr. Tini? Yes, okay. Right. Okay. Good. Is that a question? Hand raised. Okay. Right. So thank you very much. So the title of my presentation today is Hybrid Body Corporate Entity, which is actually a new, quite a recent business entity in Malaysia. And for the purpose of today's lecture, I'll be highlighting some of the various types of LP, but with special reference to the Malaysian LP. I'm using the word PLT here because in Malaysia, the limited liability partnership has to use a specific name, Perkongsian Liability Terhad, which is actually translation of LLP. And this is the term that we need to put to attach to the business name, i.e. PLT or Perkongsian Liability Terhad. So basically, this talk will be looking at limited liability partnership in Malaysia. That is Perkongsian Liability Terhad or PLT. Right, for the sharing of knowledge session, we're starting off with introductions and explaining briefly on the doctrine of corporate personality, which is very important to discuss about the hybrid corporate entity. Then I'll be highlighting about business in Malaysia and focusing on our main topic today is on limited liability partnership, and then going straight to Malaysia LP and finalizing with the conclusion. Right, so basically as introduction, just to highlight that in all over the world, basically we have three main business entities. There are sole proprietorships, partnership, and sole companies. And it is obvious from if you look at the expansion or the evolution of business entities, right, from these three main business entities, it evolved or developed into various types of business entities. For example, even the sole proprietorships and partnership structure, even though they are informal business entities, they also evolve. And in some certain countries, sole proprietorships and partnerships are also recognized as legal persons. And in corporate structure, it is there are more evolutions or developments as far as partnerships, as far as companies are concerned. And for example, I give here the United States of America, the partnership structure evolved to include limited partnership, and then it moved on to family limited partnership and also to master limited partnership. So it means that from general partnership, it evolved to limited partnership, that evolved to family limited partnership, it evolved to master limited partnership. So the evolution of business entities are basically happen because of the practices and how the law try to facilitate the conduct of businesses. Right. I'm not focusing on other type business entity because of the main agenda here is to talk about the body corporate entity. As for the body corporate entity, there is a very common misunderstanding that whenever we come across the word body corporate, it is actually referring to a company. It is a common misunderstanding because actually body corporate can refer to any entity which the law recognize as having body corporate status and therefore become a separate legal person and have its own rights. As far as corporate is concerned, the body corporate entity is actually established under the law, under the doctrine of corporate personality. Now, I'm going straight to the doctrine of corporate personality. So basically, the doctrine of corporate personality is the main doctrine or the legal theories which justify the existence of business entities as a legal persons. And even though the term used is body corporate, as I mentioned earlier, it is not necessarily meant only for companies. It can be bestowed on any business entities as long as the law recognizes it. And once it's bestowed the status of a body corporate, it becomes a legal person and it has distinct legal existence than the members or the shareholders or the directors. It means that the business entity become a legal person on its own. And the existence of a body corporate as a legal person is actually established as a juristic person or artificial persons. And there are many literatures, writings on the recognition of the law of a juristic persons. For example, Maitland highlighted that besides men and natural persons, so we, the human beings, are known as the natural persons. The law also acknowledge or recognize subjects of property rights, certain fixtures and juristic person as one species of discuss, and it knows as the corporation. Means that a company is also recognized, or a corporation is also recognized as a legal person, but not as a natural person, but as a juristic person or an artificial person. Wolf highlighted that in the study of jurisprudence, the separate legal personality of corporation is based on theories, which are concentrated upon the philosophical explanation of the existence of personality in beings other than human individuals. So again, literature highlighted that the existence of body corporate is through the theories of jurisprudential, which basically justifying the existence of body corporate as an artificial person or juristic person. Right. So according to the famous English jurist Zuhairah, he highlighted that in his study, in his research, saying that a person is any being whom the law, sorry, right. A person, I'm just trying to reduce because I cannot see. Okay. Sorry, because right, a person is basically any person which the law regards as capable of having rights or duties. Any being that is so capable is a person, whether a human being or not, and no being that is not so capable is a person, even though he may be a man. People are the substance of which rights and duties are the attributes. It is only in this respect that person possesses judicial significance, and this is the exclusive point of view from which the personality receives legal recognitions. So what Fitzgerald is trying to say that once the law recognizes entity as having capable of rights and duties, then that particular entity, whether it's a human or a not human being, can be recognized as a legal person. Once an entity has been recognized as a legal person, then it means that that particular entity shall have rights and also obligations under the law. So basically, it is important for us to understand that the notion of juristic person or artificial person can be bestowed to any entity which the law recognizes. So it means that as far as legal person is concerned, under the law, we have two types of person. We have human being as natural person, and we have any other entities which the law recognizes as a legal entity known as juristic or artificial person. Right. So again, highlighting in my PowerPoint, stating that juristic persons or artificial persons are referred to any other legal person other than human being. Now, as far as body corporate is concerned, right, in the writings of Dan Cohen, he highlighted that being merely a metaphorical existence, corporate personality therefore must respond to the corporation as well as conforming with and making intelligible the treatment of organization as legal actors. So it means that because of its metaphorical existence, because of its juristic entity, because of its artificial entity, the company or the body corporate actually depends on the human being and also the organization of the entity in order to act. And how they act and how they are recognized, basically, as I mentioned earlier, they are justified by legal theories. And according to Hallis, there are many theories which explain the nature of corporate personality, but none of them say it to be predominantly accepted. So whenever we do research on juristic person, we see we find that there are many theories which justify existence of body corporate as an artificial legal person or juristic person, but none of the theories is actually is accepted as the majority of predominant theories, and therefore we can apply it. And that's why the approach of the court, whenever they wanted to establish the principles of juristic personality, they can adopt any of the juristic personality theories. Nonetheless, according to Dewey, there are 5 main principles theories which are used to explain corporate personality, namely the fiction theory, realist theory, the purpose theory, the bracket theory, and also the concession theory. Now, so as I mentioned earlier, there are 5 main jurisprudential theory which are adopted in order to explain artificial or juristic personality. Now, the fiction theory basically highlighted that legal personality of entities other than human being is the result of a fiction. Therefore, not being a human being, corporations or any corporate entity cannot be a real person and cannot have any personality on its own. So this is one of the famous theory applied by the court, saying that a company or any religious body or any entity which have a juristic personality, they are not actually a person in the normal sense, but they are actually only a fictitious entity. Now, the propagators of this theory highlighted that human being is the only natural person, while legal persons other than human being is fictitious and depended upon the law to attribute it with legal personality. So according to this fiction theory, whatever rights that has been bestowed to the artificial legal person depends on what the law decided to attribute it with. Now, the second theory, which is a concession theory, depends on the state. So the concession theory or the state theory highlighted that is the state that have the power to recognize whether an entity can become a legal person or not, because the state is considered as having the power to establish any legal person. Now, the main difference between the fiction theory and concession theory is that the fiction theory ultimately is actually a philosophical theory, whereas the concession theory highlighted that the existence of the artificial person as an artificial person is actually because of the state recognize it as a legal person. So in the concession theory, there's a source, right, i.e. the state which recognize, whereas under the fiction theory, it can be any laws which recognize the entity as a fiction or artificial legal person. So both theories, fiction and also concession theory or state theory, highlighted that the existence of body corporate as a juristic person is not basically focusing on the entity as a legal person, but as on the concept or the fictitious existence of the entity. Now, purpose theory highlighted that generally only human beings can become a person and have rights. And therefore, any other entity, i.e. juristic person, can exist, but they are not a legal persons as had understood to a natural person, but merely a subjectless property to a particular purpose. So that's why it is called purpose theory. It means that the existence of that particular entity is for certain purpose. So it becomes legal person, artificial person, for a certain purpose, and with the completion of that purpose, or if the purpose cannot be established, then basically the entity shall not be recognized. So basically, with the registration, if you use the purpose theory, existence of a company or any body corporate entity is for a certain purpose. So the purpose must be identified in order to make it a legal person. And also, under this theory, it is necessary for the law to attribute personality to the corporations for the purpose of being capable of having rights and duties. So again, it reflects the findings of the proponents of the concession theory that only upon the recognition of the law by the states that the attributes or the rights of the body corporate can be exist, can be bestowed upon the legal entity. Now, symbolic story is actually a little bit similar to purpose story, but it is a little bit different in the sense that under this symbolic story, it's stated that the juristic principle of corporation is only a symbol to facilitate the working of the corporate bodies. It means that it is there, it is recognized under the law as a juristic person for the purpose of making the body corporate or the corporation entity to be in operation, right? So only the members of the corporations are persons in real sense of the term, and a bracket is put around them to indicate that they are to be treated as one single unit when they form themselves into a corporation. So it means that only the person behind the company will be regarded as the real persons, and the entity in which all these persons are together, right, forming a corporation are known as juristic or artificial person. Finally, a very interesting theory, which is actually applied by most of the socialists. It says that a company is as natural as a human being, right? So the proponents of the story highlighted that it is a psychological reality and not a physical reality. A corporation is a social organism, while a human being is regarded as a physical organism. So they come to the extent that they identify the anatomy of a body corporate. Says that, for example, the heads of what part is the heads of the company, what parts are the heads of the company, and so on. And according to the realist story, the law has no power to create an entity, but merely has the right to recognize it or not to recognize an entity. Every collective group has a real mind, a real will, and a real power of action. A corporation, therefore, according to realist theory, has a real existence irrespective of the fact whether it's recognized by the state or not. So they go to the extreme saying that once a company has been registered, once a body corporate has been bestowed upon a business entity, it becomes a real person, as real as a human being, and they have rights and obligations similar to a human being. So this is the proponents of a realist story, which highlighted that the existence of body corporate can be as real as a human being. Now, all these theories basically, as I mentioned earlier, there are many other theories, but all these theories basically highlighted the existence of body corporate as a legal person. And this, for example, in Malaysia can be evidenced in the Companies Act, whereby the law has already recognized company as a body corporate. And because of being an artificial legal person, i.e. a body corporate, under the law, for example, Section 20 and 21 of the Companies Act, bestowed upon the company as a body corporate, a separate legal entity, perpetual successions, the right to be sued and to sue, the right to acquire, own and hold property, and also to enter any legal and enter into any transactions, i.e., including the power to take legal proceedings. So basically, if you look at Section 20 and 21, they are basically the attributes of a company generated because of the entity as a body corporate. So once an entity has been given the legal status as a body corporate, the law will then give them certain attributes or rights, and which enables them to function as a normal person, like not the physical act of a normal person, but any other act. For example, the right to own property, the right to set up new companies, the right to take legal proceeding, and so on. So these are the important attribute of a body corporate, which has been bestowed by the law due to the existence of the body corporate as a legal person, i.e. juristic person or artificial legal person. Now, understanding the concept of body corporate as an artificial legal person, then only we can move to limited liability partnership, being a hybrid body corporate. Now, limited partnership is known as hybrid business entity because it combines the attributes of a company and also the attributes of a partnership. The external attributes of a limited partnership actually reflect the attributes of a company. It has the status of a body corporate, and therefore it has similar general external attributes as a company. However, the internal regulations or the flexibility of limited liability partnership is actually similar to a partnership. So it combines the best attribute of a company with the best attribute of a partnership, and it becomes a hybrid business entity. Now, the limited liability partnership structure is available in most of the countries. For example, in United States of America, United Kingdom, Singapore, And in the Southeast Asia, it's actually available only in Malaysia and Singapore. And it's also in Asia, it's also available in India and Japan. But all these, even though they are known as limited liability partnership, they have different characteristics. Now, as far as legal status is concerned, right, a body corporate, limited partnership, limited liability partnership can be a body corporate or non-body corporate or a partnership. So look at the, I'm sharing, right. For example, in UK, India, Singapore, and Malaysia, LP is recognized as a body corporate, and therefore it will be similar to a company having the entity as a legal person. In Isles of Jersey, for example, which is the offshore of the UK, it is known as non-body corporate, but also as a legal person. And in USA and also in Japan, LP is have the status of partnership, but as a legal person. So once we understand the concept of artificial legal person, it means that it does not necessarily mean that it must be a body corporate then only become a legal person. It can only be bestowed, can also be bestowed on no body corporate as in Isles of Jersey, United Kingdom, and also to partnership as in United States and Japan. Now, partnership structure in Malaysia is not a legal person, whereas partnership in most of the civil countries, for example, in Japan, Thailand, they are known as a legal person. So they have, once they become a juristic person, as I explained earlier, then they have rights and obligations similar to what a body corporate has. So as far as LP is concerned, right, it depends on the recognition of the law of the country. So for example, in Malaysia, it is recognized as a body corporate, similar as in the UK, India, and also Singapore. And in other countries which has LP, it depends on the recognition of the law. For example, in US and Japan, it is recognized as a company. And is recognized as a partnership with entity as a legal person. Now, as far as liability is concerned, limited liability partnership as quasi-limited liability means that the LP will be accountable for all the business debts, but if the debts incurred by the LP is actually the default of any of the partners or the members of the LP, then the defaulted partner shall be jointly liable with the LP. So it means that the limited liability protection is not available as comprehensive as in a company, because in a company, the company will be bearing all the costs of the business debts. Whereas in LLP, right, the LP will be accountable, but the defaulted partner or defaulted members will also be jointly liable with LP, and that's why we have the notion of quasi-limited liability, not a whole limited liability protections on the members. Registration, compared with sole proprietors and partnership, LLP must be registered. It must be formally, means that the documentation must be proper, submitted to the registrar of LLP. However, there is no submission of incorporation document, which is actually quite complicated as happened in registration of companies. So basically, as I said earlier, it combines the flexibility of a partnership, but it is actually a formal structure. So for LP, it must be registered in order for it to exist legally. However, the submissions of incorporation documents are more flexible, are more simple compared to the submissions or incorporation of a company. Disclosure requirement, right? As in a company, the company basically must submitted audited account report, must submitted the annual report, and there are many disclosures documents which must be submitted to registrar. But for the LP, there's no disclosure requirement except for the LP is required under the law to keep a proper keeping of accounts and documents, and also they have to submit annual declaration of solvency. So these are the only disclosure requirements imposed on LP. So again, it's not as complicated as a company, but it is more formal compared to partnership and also sole proprietorship. Now, as far as external regulation, as mentioned earlier, it is regulated by specific act. In all the countries, they have limited liability partnership, including Malaysia. So it is regulated by specific statute. However, as regards to the winding up procedures, it applies the procedures under the company side. So whatever procedures applied to winding up of companies and receivership of a company, insolvency principles applicable in company will also be applicable in LLP because of its external attribute, basically similar to a company. Now, as far as internal regulations, so if a person who studied the company law understands that company is regulated by its constitution, previously known as Memorandum and Articles of Association, whereas for the LLP, although it's a body corporate entity, even though it's a legal entity, it is not regulated by constitution similar to a company, but it is regulated internally by partnership agreements between the partners. So again, as far as internal regulation is concerned, it is flexible because the partners decided how to regulate them, the business on their own, compared with a company whereby the Companies Act actually dictate how the company shall be regulated or how shall the company shall be run. Even the director's power must be in accordance of the Companies Act. Whereas in LLP, the internal regulations are more flexible. It depends on the partnership agreement between the partners, or we call it LLP agreement, not partnership agreement, but it is actually similar to the nature of LLP agreement is actually similar to partnership agreement. I.e. that it depends on the partners. It depends on the members of the LLP to decide how to regulate the business between them. However, in order to assist the members, the LLP Act provides default rules. It means that in absence of any agreement between the partners of LLP, then the default rules of the LLP Act will apply, right? So it is similar like in Partnership Act, we have Section 36 of Partnership Act 1961, which provided the default rules for partnership agreement. The same with LLP, there are also default rules for the partners to apply in the circumstances that they have no written agreement or formal agreement. And then for composition of partners, there's a requirement of minimum 2 persons, but there is no maximum number of partners. And there's also requirement among the partners, there must be one partner who is appointed as a compliant officer, which has to basically commit to certain statutory responsibilities, which are actually similar to a company secretary in a company structure. So basically minimum 2, no maximum number, but one of the partner must be a compliance officer. We look at what are the duties of compliance officer when we go into detailed specific provisions under the LLP Act in Malaysia. As far as protection of third parties concerned, as mentioned earlier, the LLP will be responsible for all the debts to the creditors, and different than a company, the defaulted partner will also be jointly, basically referring to the quasi-limited liability. So it means that the third party can take action against the LLP for their debt, and also for the against the defaulted partner for being jointly liable with the LP for the debts of the business. And there's also clawback mechanisms, means that during the insolvency of the LP, right, within the 2 years, within the period of 2 years before the insolvency, the liquidator can, the receiver can basically retrieve back any profit distributed before the insolvency of the LP, for the backdated for the period of 2 years. So this is what we call clawback mechanism, means the liquidator or the receiver can take back all the profits which has been distributed within the period of 2 years before the LP went into liquidation. And tax regime, which is very important for business entity, as far as LP is concerned, it depends on the status of respective country. For example, in UK, Singapore, United States, and Japan, LP is taxed similar to partnership, i.e. on the income distributions of partners, means that profit which has been distributed to the partners, and the partners will be taxed, not the LP, not on the entity, but on the income of the partners. So this is actually the similar to any partnership taxation structure. So the same applies to LP in the UK, Singapore, United States, and also Japan. Whereas in India, for example, they are taxed as similar to partnership, but they have a flat rate of 30% taxation rate as far as partnership is concerned. So LP, although they are taxed as a partnership, but they are taxed on the entity at a flat rate of 30%. In Malaysia, all the LPs are actually, because of the notions or because of the status of body corporate, they are taxed similar to a company. So basically, in Malaysia, we have a different tax structure compared to any other LP in all over the world. So basically, if you look at the other LLP, they are taxed based on as a partnership, either on the income of partners or on the entity as a partnership. But in Malaysia, the LLP is actually taxed similar to a company. Now, with the general concept of what is LLP practiced in all over the world in other countries. So we're going into specifically on Malaysia LP. As I mentioned earlier, Malaysia LP, we are using the word PLT, per Konsel Liability Terhad, and it is governed by the Limited Liability Partnership Act 2012. That's typo. I missed the Limited Liability Partnership Act 2012. Now, in Malaysia, the legal status of LLP is as a body corporate, as mentioned earlier. This has been provided under Section 3(1) of the Limited Liability Partnership Act 2012. And in as far as the limited liability notion is concerned, is also partial or quasi limited liability, whereas the liability is liable, the LLP is liable for all debts of the business, but the defaulted partner will also be jointly liable for the debts incurred by the LP for his default. However, the innocent partners, i.e. referring to any other partners other than the defaulted partner, shall not be liable for any of the business debt. This is provided under Section 21, Section 1 until 21, Section 5 of the LLP Act. As far as registration, as mentioned earlier, LLP is a formal entity because of the body corporate status. So it must be registered with registrar, i.e. under the Syarikat Sunjaya Malaysia or CCM. And this is governed actually under Section 19 of the LLP Act. And however, although it must be registered, there's no requirement for submission of incorporation document. As far as disclosure requirement, similar to any other LP, in Malaysia, there's no audit requirement and no submission of dated account is required to be submitted to registrar. However, there must be a proper keeping of 7 years of accounts and documents. This is required under Section 69, and also it has to submit annual declaration of solvency. As far as external regulations, so basically it's regulated by the LLP Act 2012, as I mentioned earlier. So it is also governed as far as the winding up and also the insolvency procedures. It is governed similar to the Companies Act and also all the regulations applicable for winding up. Internal regulations is regulated by an agreement between the partners, which I mentioned earlier, similar to a partnership agreement. And the default rules of the LLP is provided in the second schedule, Section 9 of the Act. So it means that in the absence of any agreement between the partners of LLP, then the second schedule will come in, becomes the partnership agreement or the LLP agreement between the partners. Composition of partners, similar to any other LP. In Malaysia, the minimum number is 2, but there is no maximum number. And also, there must be at least one compliant officer, as I highlighted earlier, provided under Section 27. So if you look at the duties of the compliant officers, so basically, the compliant officer, a partner must be a citizen or permanent resident of Malaysia and ordinary resides in Malaysia. So that's a requirement for compliant officer. And their duty shall be, they are answerable for all the doing of all acts, matters, and things are required to be done by the limited partnership under Section 17, 19, and 20, i.e. all the documentations, including the solvency declaration, must be submitted by the compliant officer. And also, they will be personally liable to all penalties, including administrative penalties imposed on the LLP for any contravention of those sections. Means that if the LP did not submit all the documents or the obligations required under Section 17, 19, and 20, then the compliant officer will be personally liable for the penalty. So the compliant officer is basically, as I mentioned earlier, the duty is akin or generally similar to duty of company secretary in a company. As far as protections of third parties, so again, Section 21 provides that creditors have the right to claim against the LP and also against the defaulted partner under Section 21. And also there's a clawback mechanism under Section 22 of the LP Act, whereby, as I mentioned earlier, notwithstanding anything under this Act, a partner or former partner of a limited liability partnership who receive a distribution from the LLP, when the LLP is insolvent and knew or ought to have known at the time of the distribution that LLP was insolvent, or which results in the limited liability partnership becoming insolvent, and you or ought to have known at the time of distribution that the LP would become insolvent as a result of distribution, shall be personally liable to the LP for the amount or value of the distribution if it was received within a period of 2 years before the commencement of the winding up of the LP. So this is what we call the clawback mechanism, means that the liquidator or the receiver can take back the distributions of income of the LP which has been paid to the partner or the retired partner for the period of 2 years before the commencement of the winding up of the LP. Right. So, and then finally, we go to on the tax regime. So basically, as far as Malaysia is concerned, as mentioned earlier, the tax is on the entity, i.e. on the LP. This is provided under Rule 10 of the Inner Revenue Public Ruling, number 5, 2015. And the rate is actually similar to a company, i.e. 25. As far as year 22 is concerned, is 25% from the profit taxation, taxable profit. Right. So, the question is now, can a partnership or company convert to LP? The answer is yes. Under the LP Act, Section 29, Section 1 provides specific provisions stating that a conventional partnership may convert to LP. And convert here means transfer of the properties, interest, rights, privileges, liabilities, obligations, and taking of the conventional partnership to the LP. Everything. So basically, partnership under Section 21 can convert to LP. And under Section 30, right, the Act allows conversion from private company to LP, right? So a private company under Section 30 may convert to LP if there is no security interest in the assets subsisting or enforced at the time of application, and the partners of the LP is to be converted comprise all the shareholders of the private company and no one else. So basically, that's why it's applicable for private company, not for public company, because by virtue of the conversion in Section 30, all the shareholders of the private company shall become partners of the LP. So the definition of converts is similar, same as the definition of conversion in Section 29 for the partnership. Now, the interesting part of LP under the LP Act, it also provides specific provisions for professionals LP. Means that professionals can also form LP. However, at the moment, only professionals provided under the first schedule is allowed to set up LP. But as far as professional LP is concerned, it can only be formed between professionals which comes from the same profession. For example, architects, engineers, quantity surveyors, accountants, and all lawyers. It must come from the same professions. This is provided in Section 8A. And the partners shall regulate their activities by way of contract among themselves, which must be incorporating requirements of the professional ethics and regulation. So professional LP refers to professionals body, professions which are governed by professional bodies, and they conduct their businesses as LP. Now, it is also clearly stated under the LP Act, Section 8B, provided that the LP cannot limit its liability below the compulsory level of insurance, which must be approved by the registrar of the company. Right. So at the moment, as I mentioned, the first schedule only provide 3 types of professions, i.e. chartered accountant, advocate, and solicitor and secretary. So although the first schedule basically confined to these 3 professions, but under Section 92 of the Act, the minister may, by order published in the Gazette, vary, delete, add, substitute, or otherwise amend the first schedule, second schedule, and third schedule. So it means that if there's any other professions intended to be included under the Act, they can apply to the minister for the professions to be included. But normally for other professions such as engineers, architects, doctors, because under their Professions Act, they are allowed to set up companies. Whereas for, as we can see, for the accountants, solicitors, and company secretaries, they are not allowed to practice under the Companies Act. They cannot register their business entity under the Companies Act. They can only register as a sole proprietor or as a partnership, as a firm. And therefore, having LP will be an alternative business option for them to carry out their businesses, which is actually providing them a better liability regime compared to partnership and also sole proprietorships. And this explains why there are other professions such as I mentioned earlier, architects, engineers, doctors, they are not yet governed under the LP Act because they under their professional body regulations, they are allowed to set up companies. Whereas for these three professions, they are not allowed to set up their businesses under the form in the form of a company. Now, in Malaysia, I mentioned about the Malaysian PLT, but it's also interesting to highlight that we also have LP in our offshore, that is Labuan. But because of the entity of our offshore, Labuan has its own regulators and it's governed by its own act, i.e. Labuan Limited Liability Partnership and Labuan Limited Partnership and Limited Liability Act 2010. And the name, they are using the word LLP, not PLT. So the name of Labuan LP is Labuan Limited Liability Partnership, and they are governed by the Labuan Limited Partnership and Limited Liability Partnership Act 2010. Whereas for Malaysia, for the other than the offshore, we are using the term Perkongsian Liability Terhad, PLT, and it's governed under the LLP or PLT Act 2012. Despite the difference in names and the laws, right, both Labuan LP and Malaysia PLT has the status of a body corporate, and therefore they have similar attributes to companies, but they have similar partial or quasi-limited liability for the defaulted partners. Internal regulations similar, both have based on partnership agreements or the agreement between the partners and also the default rules under the Act. Right, as far as the parties creditors protection is concerned, right, the requirement is for, again, they have the rights to sue the LLP, and requirement for the accounting reports in Malaysia under the LLP Act requires 7 years, but under the Lawan there's no specific period required. They just stated that must be keeping of proper accounting records which give a true and fair view of the LP state of affairs. And in both LP, there's clawback provisions applied. Formalities, both Labuan LP and PLT, Malaysia PLT requires formal registration and also annual declaration of solvency. Tax regime is very interesting in Labuan, being an offshore. There's no tax for non-trading entity, but for the trading activity or for the trading businesses, they will be taxed on 3% only. Whereas for the PLT, they are subjected to corporate tax. And as I mentioned earlier, at the moment for year 2022, corporate tax is actually at 25%. Right, as a conclusion, stating that due to the combinations of the attributes of partnership and a company, LP is known as a hybrid business entity. And because of the notion of the status of body corporate, it is called as a hybrid body corporate entity. And being a body corporate, it must get recognition of the law, and therefore it requires formal registration. However, it is less formality compared to a company. And because of its attribute as a body corporate, it has all the attributes of a company except for the protection of limited liability. It has quasi-limited liability protection. And as for the interregulations I mentioned earlier, it's not governed by the Act, it's governed by the agreement between the partners. But as I mentioned earlier, because it's not a partnership, therefore the LP has to provide its own partnership agreement, which is provided, the default rules are also provided in the LP Act. And there's no audit requirements, there's no formalities as provided under the for the companies. So, but they must keep the keeping of the standards accounting reports and also documentations for the period of 7 years. So with that, I think I've summarized briefly about LP. So thank you very much for listening. Back to you, Dr. Atini.
Okay, Alhamdulillah. Thank you, Prof, for a very clear and interesting topic. So me myself, I learned a lot from this talk because the LLP is very new topic actually. So now I open to question. Student or any participant, you may unmute yourself if you want to ask. Okay, okay, Prof. Actually, we have one question in the chat box. The question is, can LLP company apply for tender?
Right. So as far as, thank you very much for the question. So basically now, because it has been recognized as a business entity, it should be entitled, because once the tender normally open for company, right? So basically the body corporate actually entitles the LP to be recognized as a company. So because under the even the MOF also recognized LP as a body corporate, so as a company. So by right, there's no restrictions for LP to apply for tender by right? Unless and now I was informed by SSM that there's no issue. I think previously when it was in the beginning, it's very difficult for the LP to set up even to open an account, bank account. But now everything has been become a norm. So as far as tendering process, I believe it will be the same as any other business entities is concerned. Thank you.
Okay, Prof. Next question from Gunavati. How does quasi-limited liability protect the creditor's right?
All
And
right.
then second question, whether the right of unsecured creditor is protected in case LLP is wound up.
Okay, thank you, Gunavati. So the first one is quasi-limited liability. Actually, it's better compared to limited liability. If you remember, the notion of limited liability means the members of a company shall not be accountable for any of the business debts, the corporate debts, once they have fully paid their shares. So it means that once members already fully paid up their share, then they cannot be made accountable for any of the business debts. Whereas for in NLP, the protection of limited liability is not on the shareholding, but on the defaulted regime. Means that if the partners, defaulted partners, is actually accountable. So it means that what I'm trying to say that the creditors can take action against the LP, being entity of the business, and also they can take action against the defaulted partner. Right, so it means that for creditors, they have more parties to claim compared to if the action is against a company. So against a company, if for example, if the company cannot pay the debt, so basically the creditors will have to go through the petition, wind up petitions, right? Whereas for LP, you can then try to impose on the debts of the business on the defaulted partner. So we have more options for legal actions in order to recover the debt. So that's why I say that for in LP, the creditors are having more protection because they have two cause of actions, one on the LP itself, and another one is on the defaulted partner. So they have better protection compared to a company. Of course, they are not as extensive as against a partnership, because for partnership we can make all the partners jointly liable, but for at least in LP you can make the defaulted partners jointly liable with the LP in case LP cannot resolve or cannot settle the debts. Compared to a company, the creditors are better off. And as far as unsecured creditor is concerned, because of, if you still remember in my explanation just now, the winding up procedures shall be similar to a company. So the payment of the list of preference of creditors, priority of creditors will be the same. So it means that the same principles apply. Secured creditor, fixed charge creditors, floating charge creditors, preferential creditors, and then only you have the unsecured creditors. So if you ask me, as far as winding up procedure is concerned, they have the same similar treatment as far as LP is concerned. Thank you. I hope it's clear.
Okay, thank you, Prof. Okay, so any question, student, or any other participant?
I think for lawyers it's quite new, even though it's been introduced in 2012, but because of because of the Bar Council basically contemplating on the, I think the circular, but I believe there's already circular being, I believe I was informed, maybe I'm not, I'm not, it's not correct, but I believe that there's already circular being circulated that legal firms can set up LP. Maybe Asmadi can verify this. Is there any circular, Asmadi, saying that you can legal firm can set up LP?
Assalamualaikum, Prof.
Salam.
I think, I heard, but as far as the limited liability, I think it's still with the what we call it the concept of partnership, we are allowed to consolidate the legal firm only, but not for the liability. And me also, I have got one question to Prof. Any chances in the future that Bar Council will allow for the limited liability to be applicable to the practitioner? And what do you think, if can? Is it is more secure, or is not so recommended?
I remember during a discussion, with the Bar Council in the beginning of the introduction of the LP, even though the Act, if you notice, the first schedule allows advocate and solicitor to practice as LP. If you look at the first schedule, it's stated that one of the professions allowed to be set up in LP form is advocates and solicitor firm. But it was not actually immediately not for accountants. They immediately accepted this good opportunity, and you can see many accountants or auditing firm already converted into LLP because of the benefits of LP to the profession, because of the quasi limited liability compared to a partnership joint liability. But I was informed one of the hurdles of the Bar Council is that on the tax structure, because legal firms are already used to the taxation as based on income distribution on partners' income, whereas for LP it is tax based on the corporate entity, and it will have the same rate as a company, 25%. Unless it's considered as SME, then you're entitled for 17% of tax. All right, but it means that one of the pulling the negative effect of the negative factors is actually on the tax structure. I don't think it's so much on the liability, because the defaulted partner will still be jointly liable with LP. So it still means that all partners still must have high standard duty of care. But I mean, I think the only setback is on the tax structure. I was informed one of the setback. Maybe there are other setback, but I think the main setback is because of the tax structure. Because of the firms, they are used, and they prefer to be tax based on the income distribution compared to the tax on entity. Mainly because we lawyers maybe we are not that smart to deal with our corporate tax structure. And because we already used to tax based on the income distribution, and I think that one. I hope everything can be resolved, because I think that LP is a very good business entity for lawyers, particularly for the small and medium legal firm, because it is able to at least navigate the liability regime, because if you set up few branches of partnership, then you're going to be jointly liable for all your branches, right? But with the limited liability partnership, you will not be liable for all your partners, but only if you are defaulted partner. So it will be good, in managing risk of the business. But as I said earlier, maybe there are certain setback because of the tax structure. So hopefully maybe the members can then request from the Bar Council on the applications of the LP as a business entity, because I've received some of the small legal firms asking about whether they can set up. But I think as far as I'm concerned, because the LP Act is very clear that advocate and solicitors is one of the profession allowed to set up partnership. To set up limited liability partnership. Thank you. So Amin, we have Amin asking
Yes,
about.
Yes, Prof. The question from Amin, since LLP is a company, can it sell their shares to the public?
All right. Thank you, Amin. First of all, LP is not a company, Amin. It is a body corporate, but it's not a company. As I mentioned earlier, body corporate does not necessarily means company. So as I mentioned earlier, body corporate can be referring to any other entity other than company, as long as the law recognizes it as being a body corporate. For example, you can have certain entity as a body corporate. For example, certain I mentioned about apa tadi ni religious person, religious institution, not a body corporate, but as a legal person. But body corporate. Yes, a religious body, for example, they are known as religious person, similar to a body corporate, but that religious person, legal entity, but they are not a company. So what we must understand is that LP is a body corporate, but not a company. And the structure is not similar to a company. They do not have shares. They have partners. So it means the way they form the LP is similar to a company. So the partners set up LP. So they have this LP agreement, whereby in the LP agreement, as what you're doing now in your project, you have to state out what will be your interest in the LP. So the interest of LP is the same. The interest of partners in LP is similar to interest of partners in a partnership. So it is not in the form of shares. It is in the form of contribution of capital. So your interest is in the form of capital contribution. So if you want back your capital, for example, what I understand is that can issue their shares to the public, means that if you want to sell your interest, the same as in partnership, you cannot sell it until and unless you offer it to the existing partners. If the other partners refuse to buy your shares or your interest, then only you can either dissolve the partnership and distributed all the capital among as has been agreed, or you can also request permission from the partners to sell your shares to any other persons other than the existing partners. But the answer would be no, you cannot share your share because there's no share in LP. Is it clear, Amin? Okay, thank you.
Okay, do we have any other question?
I really hope that when you go out there and you practice or you go for your chambering, so at least, you know, when you are dealing with any business entity from international business parties, for example, if you are dealing with parties from Singapore, most of the legal firm there already converted to LP. So when you come across the word LP in the letterhead, now you understand that, oh, this is actually limited liability partnership, because LP in Malaysia is normally actually practiced by trading businesses at the moment, and also accounting and auditor firm, but not so much by the profession. And chartered, company secretary also, many of the company secretaries firms already been converted to LP. But so I hope that by now, when you come across the word LP or PLT, you understand that you are dealing with a hybrid business entity, which is actually a body corporate, but it is not similar to a company. I think that's the main purpose objective of today's lecture, to explain what is actually limited partnership, which is actually totally different than a company, and it's also different than a partnership. In fact, it's very important for me to highlight, I forgot to put it in my slide, that under the Limited Liability Partnership Act, it's clearly stated that the Partnership Act 1961 and also all the equitable principles applicable to partnership shall not be applicable to LLP. So the provisions under Partnership Act 1961 and also any equitable principles provided, for example, the estoppel principle, remember the partner by estoppel will not be applicable in LP because there's a clear provision under the LP Act that none of the provisions under the LP Act and also the equitable principles shall be applicable. So it's not a partnership. Okay.
Okay, so
Yeah.
okay, Prof, I think there is no more questions. So maybe before we end, we can take a picture.
Yeah, can we take a photo?
And then for all participants, please wait for a while because I want to share the what we call the QR code for attendance.
Thank you very much, everybody. Nice to see you all.
Okay, wait, Prof. Kita nak ambil gambar jap.
Okay.
Okay. Okay, I try to print screen my my laptop. Okay, 1, 2, 3. Oh, maybe saya nak minta tolong student. Anyone? By Haki, could you please help me to screenshot? And please switch on your video. Okay. Switch on your video first. So after that, we can take a picture. Okay. We have Farihana
I see
here.
Dr. Ariff here. Hi, Hannah. Hi, Hannah. Thank you for listening.
Okay,
Thank you, Prof.
siapa ni? Andrea, siapa? Adiba, anyone? Saya tak boleh nak print screen. Sherry boleh Sherry? Sherry boleh tolong tak?
Okay, done I think.
Okay, boleh I try.
I will try juga.
Badrul ke?
Selalunya
Biasa.
Wah, I see combo there.
Tu. Okay. I think okay lah kot.
Thank you everybody. Thank you very much for listening. All the best for your exam.
Okay, so for staff, I want to share the QR code. And for the student company law, I will share the QR code in the group.
Thank you very much all. Assalamualaikum. Good afternoon.
Salam. Thank you, Prof.
Thank you.
Thank you, Prof. Thank you, Doctor.
Okay.
Thank you,
very
Prof.
much.
Okay, Dr. Tini. Terima kasih.